I always tell my employer clients, it's like buying the new car. And the minute that that wheel touches the road outside of the lot, boom, it drops 20% in value. And it's the same thing. The minute that employee crosses the threshold into your workplace, 3 months minimum.
Welcome to Water Cooler Justice. I'm Chris Robertson. I've been practicing employment law for over 20 years, helping clients resolve disputes and navigate challenges at work.
And I'm Sarah Goodenough, Chris's legal assistant. If you've been enjoying Water Cooler Justice, take a moment to follow us, leave a rating, or send your favorite episode to a friend. We really appreciate your support.
Our discussion today is about Chan v. NYX Capital Corp. The decision in this case cites another case we've covered in episode 5, Defoe v. the Township of Ignace. If you haven't listened to that episode yet, go give that a listen first. Now let's introduce our panelists. We've got Matt Dewar and Ellen Lowe. Matthew Dewar is a founding partner at Dunn Troon Law who practices employment law with one philosophy in mind. A good lawyer is a problem solver. Along with his 15 plus years of experience in employment law, this approach guides his work with every client, whether he's representing an individual who feels they have been wronged or a large company focusing on its overall goals. Ellen Lowe is the managing partner at Ellen Lowe & Co. She regularly represents her clients in court and at tribunals, but is equally well-versed in mediation advocacy, where she assists clients in navigating alternative dispute resolutions and negotiated settlements. Welcome back to the podcast, both of you. I'm super excited to have you both together. And Sarah, why don't you tell us a little bit about this case?
I would love to get us started. So the case today is Chan versus NYX Capital Corp. The plaintiff, Mr. Reginald Chan, began his employment on October 12th, 2021. NYX is a small real estate firm. I will also note, please remember the exact date of his hiring because this is going to become important a little bit later. So keep that date in mind. So his role at NYX was Vice President, Acquisitions and Asset Management, and Chief Compliance Officer. The employment agreement provided that he would have a 3-month probationary period. On January 10th, 2022, NYX terminated Mr. Chan. So that means he was employed for 3 months less a day and terminated 1 day before the end of the contractual probationary period. Mr. Chan filed a lawsuit against NYX for wrongful dismissal, and his position is twofold. So first, that the termination clause in the employment agreement, which contains the probationary employment clause, is unenforceable, meaning that the entire termination provision would be void. And second is that even if Mr. Chan was a probationary employee, NYX did not make a good faith determination that he was unsuitable for permanent employment before terminating him without notice. So ultimately, the court found that NYX made an improper attempt to have Mr. Chan contract out of his entitlements under the ESA, and the judge ruled in favor of Mr. Chan. He was awarded $44,644 in damages.
So Mr. Chan's employment agreement with NYX had a provision allowing NYX to terminate Mr. Chan during the initial 3-month period, quotes, at any time and for any reason at its discretion, end quotes. The decision cites another case we've covered in the past, Defoe, in finding that under the ESA, an employer does not have an absolute right to dismiss an employee. Let's start with the phrase at any time. Why do you think employers are so keen to use that phrase in their employment agreements?
So listen, when you asked me to do this one, I was like, well, this one's pretty interesting because I kind of hate this argument from an intellectual perspective. I dislike this whole at any time for any reason. Intellectually, it really bothers me. I think to the actual question that you had posed to us in terms of why do people continue to want to use this verbiage, this sort of, at any time for any reason, I think it's because it needs to make clear, and it is trying to make clear to some degree, that, listen, there's no guaranteed right of continued employment in Ontario. And so employers have to put something in the contract to signal to people who don't otherwise understand that in the non-unionized context, there's no guaranteed right to continued employment. They can be terminated colloquially at any time for almost any reason subject to some human rights legislation and some reinstatement provisions and some other pieces of legislation. So from a plain language layperson understanding, it makes some sense that you can be terminated at any time as long as it's not for cause, right? So we're distinguishing between cause and no cause in the dichotomy of employment law, but that we do have a type of at will system in Ontario as long as you're getting some reasonable notice. So I think that's why people are so married to this type of language in terms of at any time for any reason, because it's true, colloquially speaking. You can be exited anytime, any reason, as long as you get reasonable notice of the termination. So I think that's why people struggle with it so much in terms of this sort of technical nuance and parsing apart the actual verbiage of those termination provisions.
Yeah, Ellen, I think that's a great point. I mean, I often advise employees that you can be terminated for arbitrary reasons. The employer doesn't like the way you laugh, right?
We don't like your
Um,
sweater, and it's Tuesday.
right. So, like, I think that is something for employees to take away. Matt, your thoughts on the phrase "at any time"?
Well, with the utmost respect to my learned colleague, Emma, just to
Uh
make
oh.
this
Uh oh.
exciting, I think she gives the game away when she says almost any time, right? I mean that's where it lands because yeah, you mentioned the Human Rights Code, which is obvious. You can't violate the Human Rights Code, but the ESA lays out bare minimums that we must to which we must all adhere. And so I didn't count. I probably should have counted the number of protected leaves that are there, but the most obvious one would be maternity/parental leave. But you've got caregivers leave, you've got voting for that matter, or reservist leaves, and on it goes. And so, if we buy into the idea that we all, going all the way back to Mocktinger, the idea that you're free to contract out of the ESA, sorry, you're never free to contract out of it. Sorry, what I say is you're free to contract out of the common law, excuse me, as long as you don't violate the ESA. Well, what does that mean? And the courts are constantly coming back, particularly on employers. I ain't saying it's right, but this is the world we live in, to say you got to get it right and you got to get it right out of the gate. And if you don't, you're done. So how do we solve a problem like at any time? And the answer is easy, right? The answer is easy because it's at what I've been doing. It sounds, look how important I am. But I actually saw this coming down about 5 years ago. I thought, just wait, this is gonna land. And all I do is at any legally permissible time. So 2 words, legally permissible. End of sentence, done. Go for it. Hopefully you haven't done the Waxdale nonsense and all of that stuff. But that's the way around it. And I'm sure we're going to talk about this, but I'm going to jump in anyway while I've got the floor here and say, as long as we're talking about the ESA and what's enforceable and what's not, the judge never talked about the probationary clause. The probationary clause is unenforceable in the sense that it says after 3 months. If you look at the ESA, you're an employee at 3 months, in which case you're entitled to a week. It doesn't say 3 months less a day. It doesn't say whatever. What I like to keep it. I'm going to quote our good friend Barry Fisher a little bit later, but forget about at any time. I mean, the idea is that they're violating the ESA because they're saying we can give you nothing after 3 months, which the ESA says you can't. At 3 months, you're an employee. They didn't even address that. And so I think we can talk about at any time, and I still think it's not enforceable. But the probationary clause also does that. Anyway, that's enough for now. Over to
Yeah,
you.
look, Barry Fisher, friend of the show.
Yeah,
I think we can say that. He's done enough episodes.
absolutely.
He says there are something like, 60 or 65 different provisions in the ESA that apply to termination for an employer to trip over either in the drafting process or in the implementation of the termination. So, you know, I think what we do have is we have still some debate around the phrase at any time, because there are some cases which have tried to import an analysis of Defoe that says it has to be at any time plus some additional language around discretion.
What?
I think
Yeah.
at any time is clear enough that it probably does breach the ESA because leaves are protected. For me also, I think there's an element. I think there's an element of what Ellen was saying. At any time, it feels like almost sort of like a management rights kind of phrase that you would find in a collective agreement, like we're in charge, we decide, right? And I think that's fair. I think it's important for an employer to communicate.
Yeah.
But If it goes too far, it goes too far. If
Yeah.
you breach the ESA, you're out of the game. And what I found, I think, really important, or that a lot of people don't realize, is that once the provision is null and void, it's null and void for all purposes, right?
That's
It's as
right.
though it doesn't exist. And
Yeah.
so it was interesting because the employer's counsel tried to rely on the provision as demonstrating the intent of the parties in terms of notice. And the court said no. So drafting is important at any time, probably to be avoided. And I do think there's still some room to argue about it. But, you know, I'm still getting a lot of pushback on challenging termination provisions that contain the phrase "at any time" from management counsel, particularly.
Mm-hmm.
Do you have any thoughts on that, or where that argument might have some merit or chance of success, given that leave was refused by the Supreme Court in Defoe? Matt, I'll let you go first.
Well, I can appreciate having, because I do both sides as well, and
Yeah.
so I can appreciate the idea that you've got to push back, you got to make the argument. But and it's funny, I was talking to what was his name, Andrew McCreary at the Hicks Morley up in Ottawa, and he's actually intervening in the Court of Appeal decision, not Dufault, but one of the cases. I probably should have brushed up on
Right.
that before I shot my mouth off. And he's quite passionate about it. Like he gets in. Like we're talking, we get talking about this, and he gets himself all worked up about it. But I'm a total convert on this, and so I can appreciate why. But the court is, how many times has the court said the employer is it's an unequal bargaining situation? And right, all the time. So right off the bat, you say, well, I can terminate you at any time. No problem. Fix it. It's as simple as that. And so I will now I'll invoke Barry Fisher the way I was going to. The powerful and attractive Barry Fisher. I remember he came and he said once, yeah, he came, he gave a talk at one of my old firms, and he said, whatever the ESA says, that's what you're going to get. Right? I liken it to like a telephone pole versus a tree. And some of my colleagues used to name everything. Like in the event that we terminate you on a without cause basis, you're going to get the following: bang, 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 bang. And I was like, no, that's nuts, man. Because there's so many branches to grab on the way down. Just say as simply as you can, whatever the ESA says, that's what you're going to get. And so, and I think, Ellen, you're absolutely right in the sense that the management and employers think to themselves, I need to let them know that it's not tenure, right? You're not a tenured professor here. It's always there. And I get it. And I agree with you. But the idea is all you got to do is like two words: legally permissible, and you're home free, I think, in that sense. And so I don't, with all due respect to Andrew and some of the other people that are arguing that it is somehow, well, what I meant is no, it's not a defense. I mean, no one here, I think, would have the nerve to stand up in front of a judge and say, "What, come on, you know what I was saying." It doesn't count, and the courts keep saying you're in or you're out.
Yeah.
That's it.
Yeah.
There's no sort of middle ground. Ellen.
Well,
Ellen,
that's
yeah,
it.
go
And I
ahead.
think well, I was just going to jump in a little bit. Like, I think we get to the degree where you're parsing, and I know I've seen it, and I'm sure you guys have too, on both sides of the fence. You're literally seeing questions about formatting, like physically within the contractual agreement. Where
For
is
sure.
this? Where is this language sitting? Is it in a chart? Is it under a heading? Does that heading say termination? Does it say termination for cause? Termination without cause? Does it say probation? Does it say resignation? Because we do know a couple things, right? We know the courts, it's not the court's job to fix it if it's contrary. Can't be
Right.
upheld. It's gone. It's void. We can't rely upon it. Because we know that if it doesn't, what is that? It's Movati, I think, and going way back. Or there's also what is it, Northern Metaswitch that talks about if it violates the ESA in any way, it's like math. It's 0 times 0 is 0. It's void. It can't be relied upon. And so I know that I've at least encountered some of these more creative arguments, I think, which is, well, where physically is this offending language located? Knowing that the court won't fix your mistakes based on the principles of contra pro forentum. And so being a little bit careful about, are we putting that old school commercial agreement language at the bottom, which is headers are only for guidance purposes and shouldn't be
Yeah,
relied
that's right.
upon, to try and figure out and or try to avoid those types of parsing with respect to those different violations and those different clauses in order to try and excise what might otherwise be a a potentially intrusive and or a violation of the ESA, even if it's unintentional.
Yeah, I've got sort of two thoughts. I mean, the first
Yeah.
is there is an enforceable termination provision that's been upheld by a court in Ontario. I think the case is
Yeah.
Birch v. Data Stealth.
Data
Right.
stuff. Yeah.
I looked at the provision. I don't love it, but it's been upheld by a court. So I mean, if you want certainty, there's a good place to start.
Simplicity. Keep it simple.
But I
right?
agree with you,
Yeah.
Matt. My preferred form of termination provision is about 2 lines long. I think the real challenge that we're sort of struggling with as lawyers, I think, is also that we're trying to make the floor the ceiling, in the sense that we're trying to make statutory minimums, which must be paid, the only payment on termination. Right. And common law notice subsumes, but is often much greater than the statutory minimums. And so, I understand the challenge there. I always wonder, Barry's solution is just give a little bit more.
Yeah.
Right.
That's right.
That's
ESA
his
plus a week.
solution. ESA plus, right?
Yeah.
That's his solution. I always wonder about things like, if you do successfully make the floor the ceiling, are you going to end up with claims of discrimination, claims of harassment, claims under the Occupational Health and Safety Act? Are you going to end up with collateral attacks, trying to achieve dismissal, trying to achieve common law notice or some kind of payment reflecting common law notice?
For sure.
And is there a benefit or an advantage to the employer in those circumstances? I don't know. Like, if you have an enforceable ESA provision, do you just end up with litigation that's potentially more damaging because the allegations made are frankly quite serious? And increasingly in the internet age, we're seeing people taking advantage of qualified privilege to have allegations that are in a pleading reported publicly through the news or through private publications. So, I mean, those are my thoughts. Like, I do wonder if we ever do achieve, or maybe we have in Birch, but if we ever do achieve provision that's universally accepted as limiting to the ESA minimums, are we just going to end up with more litigation on more serious allegations and end up sort of having to parse those claims down?
I just wanted to add, when I'm invoking all these other lawyers' names and stuff, but I was Jordan Reiner from Lecker and Associates. He and I, we get on very well, and I'm usually on for the employer, and he's on for the employee, and we get to test each other about where the thing is. But he says, ultimately, whose fault this is? And he says it's Levitt's fault because of Mocktinger. And he goes,
I kind of agree,
right? And he says, like, ultimately, why don't we just admit what we all know, which is we're a common law jurisdiction and everyone should get common law, right? I mean, I know, I hear, I don't know as a fact, but I've heard from several different people, like in Israel, the law is 1 month per year. That's it. There's no fooling around. There's no, like, let's do the Bardall factors and do all of that stuff. And there's no fighting over all you're going to get is the statutory minute. No, the law is 1 month per year. Been there 5 years, 5 months. Done and dusted. Now we'll all go bankrupt if that ever becomes the law here, I'm sure. But
it's not as fun.
you know.
Definitely not as fun for us. But to your point about sort of the telephone pole versus the tree, I have to admit that one of my favorite termination provisions of all time is we can terminate in accordance with the common law. Like, okay,
That's fantastic.
right?
That's great.
Because
Bring
we're
your
still
checkbook.
we're still having a fight.
Yeah.
We're still having a fight over, well, what is the reasonable notice period? What's the format? How are they going to get paid? Is it salary continuance? Is it a one-time lump sum payment? Are they probationary? How long are they? You still have this reasonable fight between people about what's fair in terms of a common law notice period. But you then kind of avoid all of these strict technical arguments about, can I employ one of my 17 to 27 different tricks to try and find some sort of non-compliance buried somewhere in this 18-page contract that might trip up the employer.
Yeah. That's true.
Well, so again, by the way, we love name dropping. We'll put that right in. We'll put that in the teaser reel for sure. Particularly if they have a lot of followers on a social media site. One of the things Barry loves to talk about, the idea that if we were just a strict common law jurisdiction, no one would do business here. He feels that if everyone was receiving these generous termination common law payments, that it would have a deep financial impact in Ontario. I don't know if that's true or not, but he seems to feel that very few employees, it's only a small percentage of employees who pursue their entitlements.
I
right?
don't know if that's true anymore. I think it would have been
Yeah,
like 20 years ago when I was starting.
right.
But I
For
think
sure, right? 20
now
years ago, yeah.
everybody, like, again, I do my employer clients, they roll their eyes and shake their head and say, like, what, why is the law so biased against us? You know, you hear all of the stuff. And I go, welcome to Ontario. Like, that's what it is. But they still do business, you know,
Yeah,
and you know, there's certain other firms that will shall remain nameless, but take every piece of garbage, and no matter how rock solid the stuff is, to make something out of it, because ultimately, I don't think in a business. I mean, they're in the business of making money, and so and I think that some of these people know that, and they simply say, we're going to push it because it's the cost of doing business. So to Barry's point, I think that employees are not afraid anymore to lawyer up and take a swing at it, and I think that businesses, they get on with it because the market's still big enough, and they know it's the cost of doing business. Well, I know I'm going to have to throw some
Yeah.
money at it, in a way you go. They're not happy about it, and I don't blame them, but
But I
that's
think
the way
that's
it
why we have
is.
so much debate about these types of provisions, because businesses, especially small businesses, want very much the ability to at least rely upon something that tries to limit the payment to just the Employment Standards Act. They might choose to pay something better at the time of exit, but I do think they want to try and control what they anticipate will actually have to be paid at the time of exit, either as a cost of doing business. But I think at least most of my small business clients understand that there's a possibility that it's not actually going to be enforceable. And so then we're into a bit of a conversation about, well, what, should it be an extra couple of weeks or should it be a month? But that does prevent sort of that greater, just broad common law notice period assessment, because you've at least got something to go back to.
yeah. I'm going to take us a little off script here today.
Surprise.
Yeah, I'm
Oh
loving
no!
this. I'm
Oh
loving
no!
this. Yeah. So Mr. Chen ultimately, he was a probationary employee, or not a probationary employee, I guess, is what the court ultimately determined. But he certainly wasn't long service by any stretch, and I don't believe there was an argument of inducement. So on very, very short service, Mr. Chen was able to recover 3 months or $45,000, right? So I used to tell people that 3 months per year of service was sort of at the long end of the range, and I would often cite Love v. Acuity,
Right, right,
where
right.
Mr. Love was like, one of three people capable of doing his very complicated and executive function in all of the city. And he fought, for a lengthy notice period in order to be able to exercise options. He ultimately got the notice period, but he didn't get the options or the RSUs or whatever they were. So it was a bit of a Pyrrhic victory. But 3 months per year of service seems very high to me. One of the things I'm really struggling with, given all of the attacks and the growing number of attacks on termination provisions, is when I'm advising employers, I've got an employee, let's say between 1 year and 5 years of service. How much notice am I supposed to give? Right? When we're at 3 months for a probationary employee, I think Condage v. Crossbridge, which was our last episode, Mr. Condage had 3 years of service. He got 10 months notice. Part of it, I think, is employers who pursue these matters to trial might be making it worse for themselves, right?
Totally,
Right?
totally. How
Like
many times? Yeah.
maybe the judgments are reflecting that a little bit. But how do you tell an employee that who's using AI or who's used a search to find some cases, and they come to you and say, I want 3 months per year of service too, right? Is there a problem here? And are you aware of the courts sort of addressing short service or some of the inconsistency in short service notice periods? Any thoughts on that, guys?
Don't you think? Sorry, I was jump in because
Go for it, man. Yeah.
I think the new floor is 3 months, right? Obviously, I mean, this case demonstrates that, but I always tell my employer clients, it's like buying the new car. And the minute that that wheel touches the road outside of the lot, boom, you've lost exit, right? It drops 20% in value. And it's the same thing. The minute that employee crosses the threshold into your workplace, 3 months minimum. Minimum. That's what it is. I'm not sure if I don't think it's 3 months per year by any means, but this case simply reinforces my point, which is you cross that threshold, 3 months, man. That's it. Forget it. You're starting at three and you're only going up. And that's what it is. Is that right or not? Well, I tell both sides of the coin to say, let's be honest. Really, even if you had something in the I'm talking to an employee at this in my example here. Even if you had something in the hopper right now, it's probably a 2 to 3 month interview process, right? One, two, third interview, probably the fourth, and that's assuming you get the job, right? Particularly these days. But right out of the hop, that you've got a 2 or 3 month period of jumping through the hoops, and you just hope that at the end you're the winner and stuff. And so I don't think the courts have maybe framed it that way or used that example, but I think they're hinting at it quite strongly, which is to say, well, we know there's cases. Who's to say that it's going to take the janitor less time to find a job than the heart surgeon, right?
Yeah.
It's still, and whatever, I'm paraphrasing, but I think that's the message they're sending, is that it's tough out there, and it really gone are the days where you send the application and 2 weeks later it's a handshake deal, and you walk in and you start the gig. It just doesn't work that way.
Yeah. Ellen, thoughts?
I think 3 months. So this guy's here 3 months less a day, right? And he gets 3 months. I think that's reasonable. I think that I agree with Matt to some degree that probably
All
if this guy
degrees.
walked in to all degrees,
All
yes,
degrees.
correct.
Come on.
No notes
Come on.
in every possible regard. We agree. Perfect. Keep this in mind for our next file. Perfect.
Yes,
Okay, great.
yes, yeah, perfect.
But I do. I think that if someone walked into your office, if you put your plaintiff side hat on for a minute, someone walks into your office and says, I didn't make it, or I just squeaked through the probationary period. I've got an offer on the table, 3 months, no mitigation, no reporting, no salary continuance. It's a one-time lump sum payment. It's my money, and I run away. I know that statistically it takes sort of 6 weeks from successful candidate being checkmarked to actually starting the job. I might be inclined to say that's a pretty reasonable proposal. So maybe you're not wrong. Maybe the starting point really should be sort of, 3 months or so.
Yeah.
And then I think in terms of, how do you do this? I think one thing that we have to kind of remember is that structure matters, right? So when you're offering sort of these longer notice periods to short-term employees, there's no reason not to put in some sort of reporting obligation or a mitigation clause such that if they do find something out, they tell the employer cuts them off or gives them a small incentive payment. And it makes everybody look good, makes the employer look good because they're giving a longer notice period.
Mm-hmm.
As the plaintiff side lawyer, I may go in and say, this looks like a pretty reasonable proposal because they're offering you 6 months and you've only been there for 3 months. But, if you find something else, you have to tell them, and then they're going to cut you off, and all these other things are going to happen. Because in my world, there's a really, really big difference between sort of that one-time lump sum payment, you walk away and you do whatever you want, versus you're doing what you're supposed to do based on breach of contract damages assessments, right? So until your damages crystallize, you're just staying on salary continuance. I think that's a harder fight.
I agree.
Well, so I take your point, Ellen. I think structure is important from the plaintiff's perspective and from the employer's perspective, and I think it has a big impact on the actual period of notice, which you don't see in court decisions, right? So that's something that an employee who has not been through this process or has not dealt with a lawyer before is unaware of, right? So that's one way I think to sort of revise employee expectations, right? I do think common law notice is subject to an active duty to mitigate. You are supposed to be out there looking for a job. It's not a free period. So I do think that there's some room for discussion. Like, I like to have a statutory declaration that you don't have an offer or you haven't accepted a new job if I'm doing a lump sum arrangement. Right. I like to know that. I like to know that the day after the check has cleared, there isn't going to be a LinkedIn announcement about the person that just received these funds starting a new role and they've only been out of work for a few weeks. I think also, let's talk about it, man. Like, some industries are in trouble, right? Like right now in Toronto, if you're working in Toronto, you can identify 2 or 3 industries that are struggling and are letting go of a lot of people. Availability of alternative employment is a Bardolph factor. If you're one of the employers in one of these industries letting lots of people go, the idea that you should expect to pay the same notice as someone terminating at the same time on arguably all the same Bardolph factors, you should expect that you're going to pay a bit more because the availability of alternative employment is going to factor into a court's assessment. Do I think that it's 3 months starting? I'm gonna agree to disagree there, Matt.
I know where you live, so that's fine. We'll sort it
Yeah,
out
no,
later.
yeah.
So,
Yeah, and you can remind me of it when we have a file together, I suppose.
that's right.
But what I do think is that if you're in one of those industries that's struggling, and you know that your competitors are also letting go of staff, whoa, like, if you're in my office saying, why do I have to pay more than statutory minimums? And you don't have a termination provision, or you have one of these at any time provisions, my answer is, well, how many people did you let go, and how many people did your competitor let go, and how many people did you let go 2 months ago, and how many people did you let go 6 months ago? And if the answers are getting up there, if the numbers are getting up there, we know that the number of jobs versus the number of applicants, the ratio is diminishing in terms of the employee's ability to mitigate. And I think that's fair ball. I do think in certain industries, perhaps, the starting point is 3 months or maybe even more.
Yeah.
The other thing I think about Mr. Chan here too is that I believe he was a vice president. He had
That's true.
He had a lofty title, right? And so, there was a lot of arguing about whether or not he was actually the chief compliance officer or not, or qualified to be a compliance officer.
Yeah.
But I think, ultimately, I think what happened here is the employer went to trial on this and lost. And so
Stupid mistake.
they're entitled to their defense, but
Sure.
45,000 plus, if it was in simplified procedure, costs up to 50,000, right?
Yeah.
So they had the cost to their own lawyer defending, the cost of the payment to Mr. Chan, and then a cost award to Mr. Chan as well. So they took a $45,000 problem and probably made it into a $90,000 problem.
Totally.
And so if it is a business, right, I think that's a fair consideration as well, right? It's something that employer clients should be thinking about or aware of. But other than that, is there anything else you want to talk about, in terms of this particular case, or maybe going back? I noticed this case also had the wax deal problem too, the cause without cause.
Yeah. Oh, it was a disaster. Yeah. Why they took this to trial is shocking to me. I mean, I would add, it's not exactly at any time thing, but you have to tell your employer clients, do you really the only people that get rich on principle are the lawyers, right? I mean,
principles are
it's
expensive.
True. Yeah, that's true. It's about the principle, and I say, yeah, in the interest thereon, right? But the idea is that look down the road a little bit here. Do you want now? I don't know how many employees these guys have, but this is Exhibit A for every single employee that they've got that they're going to let go in the future, right? That's it. Unenforceable. There's what it is. Boom. Is that what you want? Or don't you think that the smarter move here is to settle the damn thing? Or better yet, pay them out. I mean, I think I made this comment the last time I was on the show where, from the employer point of view, what I do all the time is say, you know what, let's just pay it. Just start unilaterally paying it out. Just pay it out. Because suddenly we're going to shove these guys into small claims court, right? Or there's no cost, or whatever the case. You look good in front of a judge, because why wouldn't a judge say, well, you thought it was the 3 months case? Why didn't you pay the 3 months, right? Well, Your Honor, we did, and now we're fighting over $7,000, and we're in the wrong court, no costs, et cetera, et cetera, et cetera. Or better yet, you pay it out, and they kind of go away. They sort of drift away because nobody's going to fight. Most people aren't going to fight over $7,000. It's not worth the time.
Well, and cost awards can be factored into a
That's
contingency
right.
fee arrangement, right? So if you remove the prospect of a large cost award,
That's
may change the plaintiff's counsel's view on proceeding to trial. Ellen, you had something you wanted to add too, I think.
Oh, I just thought it was an interesting one because it's a bit of a weird. I think we can all agree that it's a bit of an unusual case. So, but there are two nuggets that I think are interesting. One is that there is some further discussion about, did they give him a reasonable chance during the probationary period to try it, right? Because they don't actually get that much court verbiage about, well, what's a probationary period and what are the obligations, and is it kind of to the theme of the podcast, is it at any time, or do they have to give him a reasonable tryout period? period.
Yeah.
And so there is some actual discussion about like, yeah, he got a reasonable chance to show what he could do, and he came up lacking. So that was interesting. And then I think just to the comment about sort of continuing to pay, I always think that's brilliant because it does reduce sort of it takes the sting out of the fight, right? Because they're getting some additional pay, but it's almost a law of diminishing returns, because the longer the litigation stretches on and the more money that they have received, the less money there is to fight about, which was sort of my other observation in this particular case, which was that there was no contest on mitigation. That surprised me a bit because I'm often, and you guys probably are too, seeing kind of honestly silly arguments about, did they mitigate? Did they not mitigate? Should there be a reduction? Can we get another discount from this 3 months that we think is reasonable? But I do wonder, and I guess we'll never find out, were there offers that had gone back? Because the guy reemployed after 5 months. And when you look at the timeline of this, he waited a long time to get his 3 months worth of judgment. So I would have been interested to kind of peek behind the scenes on, we're not going to fight him on mitigation, only took him 5 months. I don't know. Maybe the plaintiff's counsel thought they were going to get 5 months because that was going to be within the reasonable notice period, and the judge was like, "No, it's going to be 3." So
I think on the right case, the second branch of the mitigation test is open to some contest, right? Because it's not clear. It's not clear to me what the evidentiary foundation could ever be to achieve that test. Right.
We did a podcast that was the first time I was on this show. Was it the employer sent 5,000 potential job thing, and she applied to 32, and the judge is like, yeah, it's good enough. Good enough. It's so I think mitigation is. Yeah, mitigation is nothing. It doesn't mean anything now. I mean,
it's one of my favorite topics of conversation because it's often improperly advanced, right? Yes. Like if I'm on for the employee and you're telling me that it's a mitigation defense, I'm salivating because I just see a cost award.
Right. Good luck.
I just see a cost award because I'm not going to factor it into my negotiations, right? If I'm on for the employer, we're going to be sending job opportunities while they are open, and we will expect you to apply, right?
Right.
And if you don't apply to an open opportunity, which is clearly comparable, then I think at least you've given the court something to hang its hat on in terms of that second branch of the test. But even there, I still think that, there's room. A good plaintiff's lawyer, has room. And I think it was Andrew Monkhouse was on the show. He said something like, mitigation, I've beat it every time. Like, I've never actually heard someone just sort of say, like, point blank, like, go ahead, right? Bring it on. And he was incredibly confident on that point. So from the plaintiff employee's perspective,
he's not
right?
Wrong
So
at all.
Yeah.
And I know last time I was on the show, we talked about my favorite case of all time, Husko, which is mostly about mitigation, where the guy is close to retirement age and he's like, you know what, Your Honor, I'm going to be honest. I wanted to build a sailboat. So I built a sailboat. I applied for 0 jobs. And the judge is like, sounds about right, my man. That seems reasonable to me. Right? I was like, perfect, great. So it's my favorite. So I won't speak with the unmitigated certainty of Andrew Monkhouse. But if I am dealing with sort of irritating opposing counsel, I will occasionally send Husko, which is like, my guy wanted to build a sailboat. Maybe he's allowed to just build a sailboat.
Yeah. Every time you tell that story, I see like a Viking longship in my mind, like not just a sailboat, but like something with some character.
It's just a fun case, right? You don't get that many fun cases. And it's just, for me, it's a fun case where I think he called his wife as a witness and she's like, no, Your Honor, he literally just spent his time building a boat.
That's great.
Did he sell the boat? Like, I don't know, maybe then it's a business.
Didn't come into it. That's a great question. Did he ask for out-of-pocket expenses to build the boat in an attempt to mitigate his damages because it was going to be a commercial enterprise? Now that I don't know, Chris. I may have to go back and read it. It's been a while. I haven't looked at it in a bit.
Well, so I think we've had a good conversation today. I've really enjoyed.
We're now wildly off topic as per usual, so that's good.
You know what? It's good to explore. It's good to stretch, right? It's an improvisational show anyway. It's unscripted, so
that's right.
Did we even talk about the new one though? The Justice Dow decision though, that's sort of throwing a monkey wrench into all this stuff from the summer?
I don't think we did. If you want to talk about it a little bit, Ellen, we've got a little bit of time left.
just as, I like shout outs, let's talk about Lee versus Wayfair for a minute. But that's kind of the extent of it. So just to throw a monkey wrench into things, sort of contra to Dufault and Baker, in the summer we had Lee versus Wayfair. Justice Dow decides it, 2025 ONSC 2959, which says the verboten language, right? May terminate your employment, quote, at any time for any reason.
Right.
And what I sort of like is that there's very little assessment with respect to it, except for Justice Howe finding that somehow, what was it, the wording in the employment contract was distinguishable to that contained in the Dufo and or Baker case, and it was fine. So he goes on and he finds the termination clause to be enforceable.
Yeah.
So
My understanding was that the at any time didn't have qualifying language or language, sort of in our sole discretion or
anytime, any reason.
My understanding is that, he sort of found that the language wasn't the same because it either lacked something or it had some additional language. And I think, to Matt's point, right, legally permissible, right, would be a great, those would be two great words to have in front of that to set you up for success, right? But as I said earlier, I think there's still room to push and fight on at any time because of that decision that you just quoted there, Ellen. I just wonder, I think I'll take my chances with a Supreme Court, leave refused over, is it a lower court decision? There's no appeal on that, right?
Not as far as I know.
I'll take my Supreme Court of Canada, sort of 9 times out of 10.
They're appealing. Wayfair's getting appealed in any event, isn't it? Yeah, and so you'll see. we'll get a rock solid. He's gonna lose. He's gonna get overturned. There's just no way. There's no difference. There's no. It's a distinction without a difference, as they say. Between that and Dufo. You heard it here first, kids.
All right. Well, so I'm always interested, but I think, right now, today, at the time that we're making this podcast and not the time that it'll be published, it looks to me like at any time is deeply problematic if you want to enforce your employment contract. Sarah, is it over to you for the concluding remarks?
Negative.
Oh.
We've already.
It's me. Okay, it's me.
We've already we mentioned the damages in the beginnings.
All right. Well, I blew it. So I guess I'll dive in. That concludes today's discussion. I want to thank our panel for a great conversation, Sarah for keeping us on track, our listeners for tuning in. If you like this episode, please subscribe, leave a review. If you have a case you want us to discuss or you'd like to share your own story of workplace drama, and we love workplace drama here, send us an email at watercoolerjustice@gmail.com. Until next time,